All right. Thank you all for joining our Ask Me Anything session in connection with Next Act, connecting international job seekers to opportunity. My name is Sarah Diviak, and I am Bridge's Director of Client Services, here to facilitate and host our session today. I'll start by going over some housekeeping items, provide a brief intro on Next Act, and introduce our legal partners joining us. A few things to keep in mind. So today, this session is being recorded, and we'll send a recording to registrants after the call. Everything we present today is meant to be educational and should not be used in replace of legal counsel. Your phone lines are muted, but if you have any questions, you can ask them in the Q&A feature found at the bottom of your Zoom screen at any time during the presentation. We will generalize your questions, but you can schedule consultations if there are any further questions on your specific instance. This AMA is hosted by Bridge. The Bridge is a full-service immigration provider to companies of all sizes. By combining purpose-built software and best-in-class legal experts, Bridge helps companies execute immigration processes that are proactive and informed while providing a superior experience to international employees. Over 450 companies across every major industry and geography have relied on Bridge to handle immigration needs. With employees from over 170 countries, Bridge's mission is to make global mobility frictionless in order to help companies achieve their talent goals and empower individuals to become global citizens. Many of you joining us today are international professionals who have been affected by layoffs. During this crisis, we found that many companies are still hiring for international talent. So Bridge, in partnership with Unshackled Ventures, Upwardly Global, and startup's founder and investor, James Richards, took action to help connect international employees with those employers. Through our website, international employees can sign up to find their next act, and employers can request to view their list for the next hires. The response from both candidates and employers has been significant since we launched. We've had more than 350,000 impressions across channels, and more than 600 growing companies have been contacted, with recruiters pouring through the talent on our next act candidate list. Through this program, we've been providing free ongoing resources, including connections to sponsorship-friendly employers who are actively hiring, webinars and legal consultations to explore immigration options, digital skill-building tools built for immigrants, and introductions to VCs that are predominantly funding immigrant entrepreneurs. On the line today, we have two legal experts from ImmiPartner, one of Bridge's partnering corporate immigration law firms. Grounded in over 2 decades of experience managing thousands of business immigration cases, they're focused on simplifying the U.S. immigration process while leveraging attorney experience and delivering transparent case processing through Bridge's software solutions. Joining us is founding partner Ting Ni and associate attorney Kruti Vishwanath. Ting began her immigration career over 10 years ago, working on visa and green card cases for researchers, scientists, and academics. Before co-founding ImmiPartner, she worked with a large corporate immigration firm in San Francisco. There, she built a team that directly handled case processing for hundreds of companies and thousands of foreign employees. Her clients range from pre-seed startups to large multinational corporations. Kruti is an associate attorney at ImmiPartner, providing immigration counsel to corporate clients of all sizes. She handles all aspects of business immigration, including work visas and green card matters from start to finish, while additionally helping clients build out robust and customized immigration programs. Kruti has been deeply involved in the practice of U.S. immigration law since graduating law school in 2014. Prior to joining ImmiPartner, she worked at a fast-paced boutique immigration firm in San Jose, where she successfully handled complex and routine business immigration matters for individuals, as well as early stage and mid-sized companies. Kruti is admitted to practice law in New York and India. It's a pleasure to have you both on the line with us today. We've received many questions from email and from our last webinar, so we'll get right to answering questions. The first one that's come up pretty frequently is, when exactly does the 60-day grace period start? Is this on the first day of termination, or is this on the day of the last paycheck or severance payment?
Yeah, great question, Sarah, and thank you so much for hosting. Kruti and I are very happy to be here. So just jumping into the question itself, again, we get this very frequently, and technically the 60-day grace period would begin on the day that you last work for the company, so on the date of termination. Even though, usually we use pay stubs to evidence work, and it can be a little confusing if you look at your payroll records. But if USCIS ever digs into it, they will consider the last day where you perform productive work as a date of termination. So in advising our clients, we definitely want to be more conservative there, especially given the current immigration climate. So yeah, that's where we need to start.
Okay, great. Another question we've been receiving frequently is, can you receive unemployment benefits while you're waiting for your visa approval, or will that jeopardize your status?
Yeah, great question again. Obviously, with the COVID-19 crisis, this has popped up a lot, given the federal and state governments aid packets that have been allocated. In the case of foreign workers on visas, we recommend them checking with the program, just because every state has its own requirements as far as when you can receive unemployment benefits. Here in California, there are a few conditions that an employee has to meet to receive unemployment benefits, and one of which is readiness to accept work at any given time. So obviously, if you're on a visa status, before you can begin substantive work for another employer, you need your visa approval. So that kind of unfortunately would mean that a visa holder is not ready to accept work right away. But I would recommend just double checking with the program before doing that.
Okay, great. Another question that we see is, what happens when you change status to B1 or B2 to buy time in between your layoff and your next status? So when your change of status is pending, maybe after the 60 days, and you receive a job offer, can you take it? And the second part to that question is, how can your H1B be transferred after that?
Hi, Sarah. I'll take this question. Again, it's a great question. We are seeing this quite often. So the answer is yes. If a candidate has changed their status to a B1 or B2 or even an H4, and if that status is pending, and if they receive a job offer, go for it, take it, because now we'll have to submit a change of status petition again from that pending B1 or H4. And as soon as the H1B is approved, we request for a withdrawal of the pending B2 or H4 status. So to just summarize, yes, go ahead and take the offer, because the candidate was previously on an H1B. It is just a matter of reviving it. So the new employer is going to revive an already present H1B and change that status from the pending B2 to the new H1B.
Thank you, Kruti. Can O1 visas be transferred?
I'll take that too. Yes, an O1 visa can be transferred. It's pretty common for O1 candidates to change their employers while they already are on an existing O1. The new sponsoring employer will have to file for the I-129 as if it's a new O1 and get that transferred over.
Thank you. Are there any risks to not transferring your H1B and instead working on an employment authorization document from a pending adjustment of status application?
Yeah, first of all, that's a great place to be in if you have an EAD that you can jump on, without having to go on an H1B. The only risk that you're really facing there is if anything goes wrong with the green card application, obviously you would be out of status. The moment you start working on that EAD, you're no longer in H1B status. So it's completely dependent on that. And depending on, what that EAD is based on. If it's from pending adjustment of status from another employment-based case, we want to know if it's been filed for more than 180 days, because that's usually when you preserve portability and when you overcome the presumption of this not being an actual, a long-term offer. And by that, I mean, when you file the green card application, you're basically saying, I have the intention of working permanently for this position. If that's a position that, you were laid off from before the 6 months mark had been reached, then obviously there's a little bit of contradiction, because that application, that position isn't there anymore. So not saying that there's actually a lot of other options right now, but I do want to point that out as something to kind of think about and strategize with your immigration attorney, so that you are prepared if the question comes up during your green card interview.
Thank you, Ting. So a question from the chat. We briefly discussed changing status to B1, B2, or H4 while you've been laid off from H1B. But if an international employee does find a job in that time frame, can they rejoin on H1B receipt notice, or do they need the approval?
They need an approval. They cannot join on a receipt notice. So this is not like a transfer where you're already on an H1B and you change your employer where you can join on a receipt notice. In this case, you're fully changing your status from a B2 or an H4 to that of an H1B. And when there's a change of status, you have to join only with an approval notice.
Yeah. And that's
and then,
oh, sorry, go ahead.
No, please.
I was going to add, and that's the case even if the change of status hasn't been approved. So let's say you file for a change of status to H4 before the 60 days is up. Obviously, it's going to take quite a few months for that application to be approved, given just how things are going right now. Within a month, you find another H1B sponsor. You don't have the, approval for the change yet, but you still can't start on receipt because you are out of H1B status technically, and you're kind of in this bridge status. So yeah, portability rules for the H1B would not apply in this context.
Okay. And then what timeline should prospective employers be told when they can join? Would it be a few months? Is premium processing back for these types of cases?
At the moment, no, but I believe that if they send in an application before the 8th of June, then after the 8th of June, they can upgrade their case to a premium processing case. But let's say there is no premium processing, and then we are seeing surprisingly early approvals in less than a month. And surprisingly, on the other side, we're also seeing it taking around 2 to 3 months. So with premium processing available in the next 2 to 3 days, these kind of candidates can feel free to upgrade their case to a premium processing one if they've already submitted it. Now, if they have not sent in their application before the 8th of June, then I believe these kind of cases can be premium processed only after the 22nd of June.
Yeah, that's right. It's the 22nd of June. Yeah, if you dig into the premium processing update release that the USCIS has put out earlier this month, it is a little confusing. Basically, if you already have a pending H1B, then you can upgrade on June 8th. So that's why Kruti was making the distinction, you have to file it before June 8th. But if you're filing a brand new H1B and you want to use it in the same category, then you need to wait until the 22nd before you can file it with a premium processing request. But I think because I think the question is pretty broad. It also, I think, covers a situation where you're looking for a job right now and you're talking to employers and you're trying to give them a context of how long to wait before you can join. We get that question a lot from both the employer and the employee, and really it's going to be case specific. And depending on which service center you file to, if you anticipate an RFE. Generally, I will say an H1B application can be put together, assuming it meets all the requirements within about 2 to 4 weeks for most companies, unless it's a first-time H1B, in which case you might want to allot an extra week or two, just to make sure you get all the information in there. And then after that, it's just processing, right? So again, with premium processing, 15 calendar days, if they're okay with it, you'll get a response. And then if you're using regular processing, you can check the timing by going to the USCIS website and actually literally typing, visa processing time. And there you can look up the different service centers and see what the regular processing time looks like. As Kruti mentioned, surprisingly, we're seeing faster than quoted adjudication time in across quite a few visa categories, and also with EADs. But that's not something that I think people should depend on, because it seems like that's still the outlier. So I would go by the regular processing time.
Thank you both. Just a reminder to our audience, you can ask your questions in the Q&A feature at the bottom of your Zoom screen, and we'll do our best to answer them in this session. So another question we had, as of today, USCIS is accepting in-person appointments at their field offices. When can we expect US consulates and embassies abroad to reopen?
Actually, we are seeing a couple of consulates in Canada, Australia actually opening. And I know that in Canada, we are able to reschedule appointments that were previously scheduled. Hopefully this summer, but we don't have a fixed mandate or any update yet on when we are going to see offices opening across the globe. I believe it's going to be dependent on that country's pandemic statistics. And also, we have to also keep in mind the kind of travel bans that the United States has already put on a couple of these countries. So maybe that would also impact their opening. We have to just wait and watch at this point in time. And last thing that I want to add here is also that I know that I read somewhere that consulates are also considering giving appointments based on visa types. So maybe not all visa types are capable of booking an appointment, maybe some visa types. So it's a wait and watch game. You have anything to add, Ting? I mean, in your experience?
I think you're absolutely right. Obviously, every country is dealing with COVID-19 differently, and the situation is different in every country. So definitely be cognizant of that as you're considering booking appointments. I think one of the only thing I'd like to add is we are aware, in certain cases, there's truly, a humanitarian reason, some sort of emergency. So if it really is something that you believe that you could potentially, make an argument for, it's always possible to reach out to the consulate and request an emergency appointment. And by that, if humanitarian reasons, I mean, if, someone's gravely ill, in the U.S., a family member, and you're stuck outside, it's absolutely, I think a good reason to see if you can get an emergency appointment. And, on the business side, if you are, let's say, a key member of your company's team, let's say you're managing a team of 15 other engineers, and the company itself would suffer a lot of economic losses, that's another reason that you might want to consider filing for an emergency visa appointment. It doesn't mean that it's going to be granted, but in these dire times, I think, people consulates have been more understanding in those cases.
Thank you, Ting. So another question we received via Q&A and we've received in previous sessions is, how does a furlough affect status?
Yeah, and I can take that. So furlough, unfortunately, has been, a reality given the COVID-19 pandemic for a lot of folks, and it really depends on what status you're in. So in one of our earlier webinars, we had talked about whether you can furlough or not, particularly with H1B visa holders, since I think a lot of, our audience today were on the H1B or are on the H1B. You're actually not permitted to be furloughed. The DOL has been pretty clear on that. So if basically that would be considered what they call, the Department of Labor calls benching, and the employers are not permitted to do so. So you're either going to have to file, by you, I mean the employer has to file a petition to amend your application if they want to reduce your hours or reduce your salary, if it's an across-the-board cut, or they actually have to effect termination for that, so that you don't work.
If you were furloughed or placed on like an unpaid leave, would there be difficulty in transferring your H-1B to another company?
If you were placed on unpaid leave, aside from the slew of issues we just discussed, from an employee's perspective, I don't see too many issues with transferring to another company. I've actually done this in other cases. The caveat there is you do have to show that you were performing, and maintaining status. So if you don't have payroll records for whatever time you were furloughed, in that case, you pretty much have to explain to the USCIS that the reason that was so is because you were furloughed by your previous employer, and thereby kind of reporting them in that they're not doing something that's permissible. So in previous cases, that's been notifying the Department of Labor and providing records. Obviously for the employee's perspective, it was fine. They weren't penalized, but obviously that would cause the previous employer issues as they are out of compliance.
Thank you, Jane. So we discussed transferring H-1Bs and transferring O-1s, but can you transfer your I-140 from company to company?
Yeah, so, and Kruti, feel free to jump in as well. So to transfer your I-140, I think you're really talking about maybe transferring a priority date. So when you file an I-140, depending on what it is, and we can get into the different categories, but assuming it's a normal perm-based, I-140, you're pretty much representing to the government that there's a permanent position with company A. So the permanent position is with company A. So you can't say, because I have an approved I-140 with company A, I now can transfer to a permanent position with company B without testing the labor market with the perm, process. But, fortunately, because there's such a long wait, our regulations allow you to port the priority date. So if you've gotten an I-140 approval already with your current employer, you get to keep that priority date while restarting the perm and I-140 process with company B. It's a little bit different if you are in the EB-1A context, where you're an alien with extraordinary ability, and it's the self-petition application. Obviously, in that case, it's completely premised on your own abilities, and so long as you're working, regardless with which employer, as long as you're working in a field, in the field of expertise in your I-140 petition, you should be okay. So it really depends on the case, but I would say regularly for any perm-based applications, you can't just transfer the I-140, you keep the priority date.
Yeah, I just want to add in that it, in summary, it also means that when they port their priority date with a new employer, that new employer has to restart the perm process again and file for the I-140. The only exception to this rule, as you said rightly, is the EB-1A and also the NIW category, because these are self-petitioned and it's not tied to any employer. So there's no need to refile another I-140 if we keep changing jobs.
Thank you both. So we've been talking a lot about the H-1B, but how do furlough implications affect the E-3 visa?
Yeah, great question. We actually have a chart on all of this, and we'd be happy to pass that out as a resource afterwards. So a couple of things. The E3 is also an LCA-based visa. So one of the requirements is for folks to be paid at or above the prevailing wage. So I think any sort of changes on that, will necessitate an amendment. But in the meantime, I think furloughing in that particular situation, there's no benching regulations the way it's been very clear for the H1B. So technically, you would be considered out of status. So that would kind of cut into your 60-day grace period if that's available for you. Because as most of us know, for most non-immigrant work visas, you get a 60-day grace period if you are terminated prior to your expiration, and you have 60 days left before that ending period of your approval. If you're furloughed, technically you would be, like, as I said, out of status, so you're cutting into the 60-day grace period. If your employer hires you back, it should be okay if it's still within the 60-day grace period, but you will not have another 60-day grace period. That's the case if you only used 20 days, you don't have another 40 days left. So that's, I know it's kind of a confusing concept, and we can, I think our chart explains it pretty well, but I would, it's not an ideal situation, and I would definitely be really aware of how much time has elapsed, and also note that if that's the case, you're using up your grace period for that approval period for your E3.
So speaking of your grace period, what happens if you stay longer than 60 days after you're laid off, but you leave before 180 days?
I would start off by saying that we are accruing unlawful presence, no doubt, but the severity is not as it would be if we overstayed beyond 180 days to up to a year, where we get a 3-year ban, and beyond a year we get like a 10-year ban. While we do not recommend anybody to overstay beyond their grace period just because they're within 6 months, I know in these current times, it is sometimes we are left, without any options, or we need some more time beyond what is allotted to us to gather our things. USCIS recently confirmed that if there are any late filings for any, extension of a status or change of status that's beyond the 60-day period, in their discretion, they could allow, they would not, hold it against you. So I still feel that we should be very mindful of our status expiry dates, and we should try and file for a extension of our current status if that is available, or even a change of status to another non-immigrant category to keep our status in line within a reasonable period. So I don't see it as an issue where it would result in a ban from admissibility going forward, but it is not advisable because it could come up sometime at some point in time if any of these candidates have to go back to their home countries and re-enter via consular route. It is not uncommon for officers back there to actually ask about these things. So it is more like it doesn't show a good faith effort to retain your status. And it could probably come up even during your green card interview at a later date. So these are the topics I would be mindful of if I really have to overstay, but still urge everyone to stay within their status period or apply for a change of status to not accrue any unlawful presence.
Yeah, and I would just say that Kruti is absolutely right. There is a difference if you overstay for 2 or 3 weeks as you wrap up affairs before departing, because let's say your child was in school, and you really needed to, and you couldn't get a flight out. Those are reasonable factors to consider if it does come up in a consular interview or your green card interview. On the other hand, if you're staying up until, the end of the 179 days, and you're leaving, it's technically, no, it doesn't trigger the 3-year ban. But are you going to have a tough time explaining why is it that you did that? I think absolutely. So just be careful there and make sure, to the extent you can document these things. It's always helpful to have evidentiary documents to point to any, in any appointments where you get to talk to a live officer. For example, in the context of what I just said with your child still in school, being still in school, I mean, there's absolutely enrollment documents you can get to show that that's the case.
Thank you, Ting. We have a lot of students joining us today. So what should students do if their OPT hasn't yet started? Maybe it's starting later in the summer and their job offer has been rescinded because of COVID.
Yeah, I mean, if that's the case, and I'm assuming you filed for the EAD, and it says OPT hasn't started, so maybe you've received your EAD. If that's the case, you do have to notify your DSO that, the job opportunity isn't any material changes. So obviously, if the job opportunity is in there, that's a material change. And you do have, I think it's 90 days of, unemployment permitted on your initial OPT. So if the job offer is rescinded and you're not working, you would be cutting into the 90 days of unemployment. So keep track of the days. If you reach the 90-day expiration date and you still haven't found another position, then you would be considered out of status and you need to leave the US before that time is reached. On the other hand, if 30 days into that window, you do find another employer, you should be able to begin working with them. Just notify your DSO so they can keep track of the days as well. Krithi, anything to add?
I think you covered it all. I just want to add that maybe it would also be comforting for students, especially on OPT, to know that even an unpaid internship stops the unemployment clock. So they have to they need to have an employer, and it's basically getting training for the field of study I'm just majored in. The first year of OPT need not be a salary-based or even a paid employment. An unpaid employment or an unpaid internship, does enough good to keep your OPT valid and to stop the unemployment clock.
And I just want to say, that's a really good point, Krithi, for OPT. There is a difference for STEM OPT, though. So OPT, the first 12 months after graduation, there's no prevailing wage requirements. But if you read the regulations for STEM OPT more closely, your employer is obligated to pay. It's not something like the H1B where you have to submit an LCA attesting that to the Department of Labor, but they are basically agreeing to that when they sign your I-983 training plan for the STEM OPT. So in those cases, an unpaid internship would not work. You do need to have a paid position in that case.
Thank you both. Going off of OPT, we have a question in the chat. I see news of banning OPT and H1B. Will there be an order in the coming days from the government?
Yeah, I mean, with these sort of things, there's always a lot of noise. Banning OPT and H1B, I can say I'm obviously not sure exactly, what that news is saying in this question, but as far as H1B goes, the H1B is written into law. So when you think about immigration regulations, there are actually many, many different types. Federal law here in the U.S. is something that's passed by Congress and then signed by the president to become law. So H1Bs, visas falls under law. So a president can't just change, this and get rid of the H1B just like that without going through Congress. Now, when you're talking about banning H1B, you might be talking about entry into the U.S. If you are trying to, let's say you have your H1B approval, you're outside of the U.S. right now, and you want to come back in on your H1B visa. The president does have the ability to control the entry of people into the U.S. Based on emergency powers. So with respect to H1B, there are limits to the emergency power. It really has to be an emergency that's happening, and it has to be for the national interest. So even though there's been some news about H1Bs being limited, it's really hard to say exactly how that's going to be affected, because obviously there are business interests kind of arguing against that, and we can all sit here and debate until our faces are blue. Is COVID-19 really the emergency condition that justifies a banning of H1B visa holders coming to the U.S.? Definitely, there's a lot of debate there. So I would be cautious of, getting too, anxious about something you're reading, just because I think a lot of it is it might not come to fruition, just given the way our system is set up. Now, banning OPT is something that I think the government it's more different. It's definitely different. OPT is not written into law. It's more like regulations that the departments have put out, allowing training. So. I think with that, it's more of a wait and see. Generally, if you're making any changes to rules like the OPT, you go through a period of comment, and then deliberation, and then action. And by you, I mean the agency administering OPT. That's a month-long process, generally speaking. That being said, in certain emergency, again, that an interim final rule can be issued. Again, there are obviously a lot of universities, a lot of business interests that have and that find OPT quite useful. In fact, I think the House GOP actually submitted a letter trying to protect OPT. I think it just came out yesterday. So again, I would be really cautious about kind of buying into that and getting too anxious about it. We'll just have to see what comes out. Sorry, that was a really long-winded response, but I hope that provides some context.
No, that's really helpful. I know it's tough to speculate what's happening right now, but that's helpful in understanding the possibilities. Are there any planned adjustments being made to the 60-day clock for anyone on a visa or F1 OPT employees due to the lack of opportunities right now?
Kruti, you want to take that one?
Yeah. Could you repeat your question again, Sarah, just so that I get it right?
Yes. So are there any planned adjustments being made to when the 60-day clock for F1 OPT or H1B individuals begins, given the lack of opportunities?
I don't think so. I think they're pretty unforgiving here. We continue to urge candidates to be very mindful of the 60 days grace period after their F1 ends or their H4 ends. As we were mentioning earlier, the only saving grace is that in case we are not able to time our change of status, during the grace period, or it could also be an extension of status, USCIS may, in its discretion, pardon such delays, provided we are able to show that those delays were truly because of COVID reasons. So we do not believe that not finding an opportunity in time, or how we took time to be able to find a suitable opportunity, is a good enough reason for USCIS to forgive any overstays on F1 or H1Bs. I'm sure you agree with this, right, Ting? Unless you've come across anything else.
Yeah, no, I wouldn't count on the government being forgiving of that at all right now, which is why we're advising a change of status to a B1, B2. If you really can't find any alternate ways of staying. Because I know folks are being limited also by flights. That's a real reason. And there is actual guidance from USCIS, on COVID, where they say that if you can't, that's what they want you to do. Go ahead and file a change of status to B1B to cite that as a reason. So procedurally, to keep yourself in the clear, I would absolutely recommend doing that. Then you don't have anything to worry about, and it's really not a very heavy lift to file the application. I know a lot of folks kind of do it themselves. If you don't feel comfortable, that's absolutely understandable as well. Reach out to an immigration attorney, and I'm sure you will be able to get the help that you need.
Thank you. So a follow-up to the maintenance of status question from earlier, if I don't have pay stubs for the last 2 months, what can I include as maintenance of status in my transfer to a new company?
Yeah, so I think I'm looking at the question as well, and I think one of the so just taking that question by itself, if you don't have pay stubs for the last 2 months because you were furloughed, kind of goes back to exactly what we were saying, right? Like, that's not permissible by your previous company. So you can go ahead and file the transfer, but you're going to have to disclose why, if it's in the case of a furlough and it's going to implicate company A, your previous employer, in doing something impermissible. Now, I think the second part of the question is, will USCIS dig deep to ask reasons why I took a personal leave of absence? So the personal leave of absence is particularly important here. So it's not a furlough if you requested the leave per the regulations at your workplace. If there's a family leave that you requested for a personal reason, and that, that's something that is granted to all employees when they ask for it at your previous work site, then it's not employer benching. You would have to explain that you asked for the personal leave of absence, provide whatever documentation you used. If it's a verbal request, make sure that you're also kind of always writing a letter or attestation or something explaining. I would do that preemptively on filing and not wait until an RFE if you don't have the pay stubs to show maintenance of status. So I think the gist of that is saying that if it's a personal leave of absence, your employer wasn't violating any regulations, you weren't violating any regulations, but explain the circumstances.
Thank you, Jane. Can you apply for a part-time H1B transfer if you're laid off?
Yes, part-time H1Bs are feasible, but again, we should be mindful of when we are applying for it. Ideally, it is, the best way is to apply for it while we are on the 60 days grace period. I also want to draw some attention here that we should know that the 60 days grace period is not a given no matter when our status ends. So we should see what our I-94 end date is. It is 60 days or the date on the I-94, whichever is earlier. So if somebody's I-94 admit is, let's say, until July 15th, then that person gets laid off today. So they don't get the 60 days. They still have only till July 15th. So it's 60 days or the I-94 end date, whichever is earlier. Sorry, I'm being repetitive here, but I just want to throw a lot of light on this so that in these turbulent times, we shouldn't get carried away with, waiting on the 60 days when we may not actually have that. So if you're filing for another H1B, even if it is part-time within that grace period, we should be fine. So USCIS has no issues with adjudicating part-time H1Bs.
Right.
One
thing to add to the part-time piece is that you really have to be cognizant of how part-time it is. If it's an hour a week, we're going to have issues if you don't have, another H1B. But usually with part-time, we see a range, folks list anywhere from 15 to 30 hours. It should at least be providing you with a livable wage. So just keep that in mind. So yeah, part-time is definitely doable. And the only other thing I wanted to add to Kriti's point about the grace period is, as I alluded to earlier, once you use a grace period in your in approval notice, you get, let's say 3 years for H1B, E3, whatever, a work visa that's given a 60-day grace period. If for whatever reason pre-COVID you've used that grace period, you took time off, maybe you were terminated and you left for 10, 15 days and you decided to come back on the same approval, you don't have another 60-day period left. So just keep that in mind. I know that's a really small group, but I just wanted to mention because it is a point of confusion for some folks.
Can you file part-time applications with multiple employers?
You can. So one good thing about the H1B and many visa types is that you can file concurrent applications, but you do have to indicate that. So I mean, I don't know what obviously the details of that setup. How many employers are we talking about? What sort of duties? Yeah, so a lot of questions there, but from a technical perspective, yes, you can file multiple part-time H1Bs.
Thank you. So switching gears to the TN visa and the E3 visa, many times these are applied for outside the US. Are there options for extensions or change of employers inside the US?
Yeah, absolutely. Krithi, you want to take this one?
Sure. Sorry, I want to.
I got it.
I don't know. I'm not able to comprehend it correctly. I'm so sorry.
No worries. So I can take that. Basically yes, absolutely. For most visa types, you can file for an extension of status here in the U.S., even if it's usually a consular processing, E3, or at the border for Canadian TNs. You would basically file a Form I-129 with the USCIS. And the good thing is, just because by filing that extension application in a timely fashion before the expiration period is up, you actually get an automatic 240-day extension. So even before the approvals come through, you have legal status and you have work authorization. So that's definitely something we're advising clients across the board to do, even folks with expirations that are like 6 months out. We're initiating the process now and filing, because 6 months is when the filing window opens for any renewal applications. The one caveat I'd like to mention is that don't forget about your dependents. So your spouse, your children, if you're going to be filing in the U.S., they need to extend their status with you by filing an I-539 application. Otherwise, just because you extend your status doesn't mean that theirs get automatically extended as well.
Thank you, Terry. So now back to another student question. If OPT is expiring, can I enroll in a master's program and work on CPT?
I can take that thing. Yes. Just want to highlight two things here. Of course, it depends. There are two things. If you're looking at getting another OPT by enrolling into a master's program, we have to be mindful that OPTs are granted only when there is a higher level of education that we are pursuing. So if I'm on my OPT from my bachelor's, and if I do enroll into a master's program, I can still get another OPT when I'm in my master's. But we are noticing that a lot of candidates who did not make it in the lottery this year, who are on F1 and have ran out the last leg of their STEM OPT, can transfer into another program and take the benefit of a CPT. What I want to highlight here is CPT programs are not universal to all universities. So you may want to check with your university and the DSO there to really understand if they do recognize a CPT program. If that's the case, then of course they can opt for CPT and work for those hours mentioned on your I-20 as per the CPT program in your university. and continue your status.
Thank you. So we had a question come in from Q&A. Can you talk a little bit about the recent lawsuit of IT Serve Alliance versus USCIS and how it affects adjudications of petitions?
Yeah, great question. So for a little bit of context, the lawsuit deals with third-party placement H1Bs. So IT Serve was an IT a company that provided workers to end clients, and for those of you guys that are pretty familiar with H1B processing and statistics there, third-party placement companies have been disproportionately affected by more stringent H1B adjudication. Relative to other companies, they're getting a lot more RFEs and a lot more denials. So basically, even for very, very large companies with years and years of history and experience kind of working in these contexts, we were seeing lots of RFEs and denials across the board. So this decision really addresses that trend, and it basically it was a resounding victory for the petitioners in a lot of ways. In terms of have we seen the change right away, I think it's too soon to say. Certainly we are, for RFEs that we're receiving, we're citing the decision and arguing that, USCIS shouldn't adjudicate these cases in the same very stringent standards that they were using. But I expect, it's hopefully going to change the situation for the IT companies, for the third-party placement companies. But again, I think it's too soon to really comment effectively on the results so far.
Yeah, I just want to add that it was definitely very strenuous, I think, on part of the employers to provide day-to-day activities, and especially the itinerary requirement where we had to list out what the candidate is going to do for the entire period of the H-1B requested. One good argument that came out of this case was that sometimes we may not actually have to, we may not be able to stick to what we said, or there could be new projects coming up. And many times projects are given based on the performance of the already allocated assignments. To give you a list of all these speculative assignments is very tedious, and it was very onerous by USCIS to request IT consulting companies to be doing that. So the decision, of course, is very victorious, and it's probably going to ease a lot of documentary collection for these IT consulting companies and as attorneys. But I would still say that we have to still test the waters. We cannot still give a very bare bone petition. We still urge employers to be prepared with key documentation like proof of the work, like an SOW or any work order that shows that these consulting companies are liaisoning with the end clients. So contracts between them, at least a rough chart of what the nature of the work is going to be, and more information like from the client saying that they are only taking a resource from these consulting companies and they are not the employer still helps. We have to still be mindful of giving an inclusive petition, if not an onerous one.
Thank you both. So as we're coming up on the last couple minutes of this session, what's your top advice for students or anyone on visa status right now as they move forward in their search?
Yeah, absolutely. I think a couple of key things that we've touched on: keep track of your dates. Collect evidence of your employment or non-employment, and be ready to file for a change of status if you need to keep lawful status here in the U.S. Even if you can't work. It really is going to, I think, number one, reduce the anxiety of feeling like you're going to be out of status anytime. And obviously, with all the craziness we're all dealing with, it doesn't feel safe to travel. So just keep those things in mind. And if I think for a lot of folks, it's also, being mindful of the implication on your families. So doing the right things to extend their status. Yeah, I think that's the best we can do right now. Certainly, if you are able to find another employer, for what it's worth, premium processing is coming back. We are seeing, adjudication is still happening. Some visa consulates are opening up. So I think there's a slight move to a sense of normalcy, in some cases. I think we can all hope for the best, but statistically, maybe there might be another rebound given how the pandemic develops.
One more question that just came in, I think is a really great one. We haven't been talking much about dependents. So after a job loss on H1B, can a spouse still continue to work on H4?
I can take that, Ting. I would say no, because the H4 is a derivative visa. The H4 is because the H1B is. That's to say that if the H1B is rattled, the H4 automatically is rattled. So although we would have a valid EAD that gives me the opportunity to work for a particular date, if the H1B is in jeopardy, I would say the EAD would collapse as well, because that's tied to the H4 and the H4 to the H1B.
Yeah, so in that case, I think it's actually a little bit of a gray area. So I think the question is, if you're on the 60-day grace period, so technically you could still transfer your application and to another H1B employer. I've definitely seen situations where the spouse kept working on the EAD and it hasn't been an issue in terms of extending it the next time around. But again, as Kruti mentioned, it's inextricably tied. So be very careful. If you kind of get up to the 60-day grace period, your spouse probably should be having that conversation with her employer as well, or his employer as well. Just because they're, at the end of that 60-day grace period, there's no question they don't have an EAD work authorization. They need to stop working because it is tied together. But I think on the 60-day grace period, there's a little bit of a gray area, and you can make the argument that the spouse could still work for those 60 days.
Thank you, Ting. All right. Any final thoughts in these last couple minutes that we can share with our audience?
Kruti?
Yeah, as a final thought, I just would like to highlight to everyone that I know there's a ton of information out there that's available easily to all of us, but the core principle is that we have to still be very mindful of our last day of termination, our status end dates, and always make sure there is a good faith effort in keeping our status in a rightful manner. There are tons of options out there to change status, to keep our status going without jeopardizing it. So it's really worth checking with your attorney or with any one of us if you have any questions. And there are a lot of also speculations on the executive orders. We are as much in the dark as you all are. So if we do know anything, as Bridge keeps up to their promise, we do put up all these updates out there as soon as we know any. For now, it's wait and watch. So don't speculate too much of what could come. We have to take it when it comes.
Yeah, absolutely.
Yeah, I was going to say that's very helpful. I know there's a lot of misinformation circulating, and we will provide updates as soon as we know more on any of the upcoming executive orders. So, Ting and Kruti, thank you so much for hosting this today. This has been extremely helpful. I hope our audience has found this helpful as well. Just to reiterate, we are going to send a recording of this call via email, but you can find updates and resources on our blog located at bridge.legal under resources. And we'll also be posting additional announcements on our social media platforms. So thank you again for joining. Ting and Kruti, thank you for all your help. We wish you all a great rest of your week.
Thank you. Take care.
It was very nice. Thank you.